Geese and Geese. I see that you recused after the MSC that Mr. Geese didn't appear at. I didn't know if you were going to keep that recusal on file and if we needed to set that pretrial over.
I noticed that myself, and I couldn't remember what the recusal was for. I went back, found it, and I, again, wasn't sure if that was the one that I had with you where there was a no-show. And it sounds like that's your recollection. I also see that it is on next week for a motion at 9 a.m. So
and that was due to your recusal. The clerks kicked that out and said it had to be on the A docket. So I wasn't sure what your thoughts were on today.
My thoughts are, let's pass readiness over. Since that recusal is still in the file, we'll pass it pretrial 2 next Tuesday the 5th at 9 a.m. and both of those matters can be heard at the same time.
Very good. Thank you, Judge.
Interim GAL report and a presentation of an order is what we're on for.
And Judge, we've already entered that order that was agreed between the parties on November 7th, I believe, that got executed. And I understand the GAL has recently begun communicating with the parties. My client has an appointment, I understand, with Ms. Height in the relative near future. So we would just ask that be continued 2 or 3 weeks, whatever Ms. Height needs to get some traction on this would be agreeable by us.
And Your Honor, Christine Dow representing Darren Barnes. I've substituted in for Georgia Petrie. And we don't have a problem setting that out. The more information we can get from the guardian ad litem, the better.
Okay. Ms. Height, good afternoon.
Good afternoon, Your Honor. As you know, I was just appointed November 3rd, so it was a very quick turnaround time. I have gotten intake packets back and had congenial conversations with both parties, and I've set up visits with both due to illness and due to days off from school. I have not yet been able to visit Adeline at school or at all yet. So I am, as Mr. Zandy said, I have some traction, but not enough to really give any information to the court.
We have our, it looks like our final GAL report is due at this point is January 30th.
Right.
Do you think if we were to review this either the 19th or the 26th of this month, there would be additional information, assuming the parties are available those dates?
You mean 19th to 26th of next month?
Of December.
Yes.
Or do you want to just, I guess, or do you feel that January 30th is the soonest you'll have kind of a complete report for us?
I think it might be most efficient to go ahead and shoot for that end of January report as a final report. I can have that to the parties by mid-January for their review.
Ms. Dow, Mr. Zandy, any concerns with just keeping that January 30th? And if there's anything that arises, it can be noted on before that?
I don't have a problem with that, Your Honor.
My only concern with that, Judge, is that we're in this position due to some pretty extreme conduct of Mr. Barnes in the middle of September, early September of this year, in which the SWAT team was called. We certainly have alcohol was at least involved, if not the root cause of that. There was some inklings of domestic violence. This is the one where the SWAT team had to tear gas him out of the home. So that we do have significant concern. We would prefer the December 19th date. The reason I say that is if there is a recommended change in custody, I think it probably makes the most amount of sense to do that prior to the child going back to school at the first of the year, as opposed to transition in late January or early February. So I would ask that we set it to December 19th. If we can have some kind of clarification or some kind of input from the GAL at that point, that might be beneficial. And if the GAL tells us, maybe that was a one-off. Certainly, we don't believe that. But if that's what comes back, then we can always adjust that. But I would like to keep this tracked, given the severity of the incident that happened in September, coupled with my client's ongoing concern.
And Your Honor, if I may, Mr. Zandy does bring up a point that our position is that our client had a mental health meltdown. It was a one-off. There are no particular issues of domestic violence or the children being present for any of this. So if it would be helpful to have Ms. Height produce at least an interim report, that would at least give us more information to work with. I mean, either way, I think that, yeah, I'm fine with an interim report sooner than the end of January, if Ms. Height can manage that.
I'm sure I can manage that. Thank you. So shall we,
If
What
the
would-
19th, does the 19th work for you, Ms. Height?
December 19th? Yes.
Okay, then let's set this for an additional review the 19th, and then we'll keep that January 30th date for the final GAL report and set the 19th for an interim report.
All right.
And
Right.
Ms. Height, I don't expect a formal report. If it's a bullet pointed email to all the parties in the court, whatever you can put together. I'm glad to know that the parties at least have been in contact with you and returned their packets. So that's good. Whatever you can get to us for the 19th would be great.
Okay. Thank you, Your Honor.
All right, thank you.
Thank you. Presentation
you.
today, Judge, from the order from Your Honor. I believe it was 3 weeks ago. I think we're largely agreed to that. I understand Mr. Baldwin has one clarification related to one provision in that parenting plan.
I thought there
Trying
was
to
no
speak for him so he can save his voice.
perfect. It was just one issue, Your Honor. It was on the bottom of page 6. I just asked to strike the section about notification for daycare given the age of the child. I think both attorneys believe that's not necessary. It wasn't necessarily part of Your Honor's actual order.
That was a carryover from the existing order, and I have no objection if you want to strike that provision, Judge.
So the entire sentence, each parent shall provide the other with their addresses and phone numbers, or just the as well as their daycare provider part.
I think just the daycare part is all that was objected to. I think they've already got their contact information, but nonetheless, that should probably stay. That makes sense. We just strike that on daycare provisions. The child's now 12 years old.
Okay, so the last sentence on page 6 now reads, each parent shall provide the other with their address and phone number and update such information promptly whenever it changes.
Yes, Your Honor.
All right, and I okay to indicate approved via Zoom for Mr. Baldwin and Ms. Height?
Yes, Your Honor.
Yes, Your Honor.
Okay, I signed that order. Thank you very much.
Thank you.
All right, this is on for a motion to provide mental health evaluation report and findings.
Correct. And this
Do we
is on my points.
And is Mr. Hitchcock present?
Yes, ma'am.
All right, thank you. Good afternoon. All right. I have reviewed the motion. I've looked back at the previous orders that were entered. I want to, it wasn't myself. I think it was another judge that initially ordered the evaluation. I did receive from Mr. Hitchcock response to the request and his concerns about Dr. Mahar's report. Any argument, Mr. Zandy?
No, I think the motion largely speaks for itself. My client just wants access to that. This case has been on the better part of hold for the past 16 months, pending that evaluation coming back. From what I understand, the evaluation has been done for several months now and has not been released due to Mr. Hitchcock pulling his waiver to Dr. Maher. In my communications or attempted communications, it was made clear that the office would prefer a court order in addition to the one that they already have to clear any potential hurdles. We did file a subpoena. We did issue that to Northwest Psychological Services. It's there. And from what I understand, Mr. Hitchcock just unilaterally decided he didn't like said report and that it was biased, which again is unfortunately kind of typical at this point, and instructed the office not to submit that contrary to the August 2022 court order. Simply asking that that be produced, simply asking that the order reflect and direct Northwest Psychological Services to issue that directly to me pursuant to the terms of the existing order. And again, consider some kind of attorney's fees and costs. My client has outlined for you some of the frustrations and some of the expense she's gone through over the past year and a half or so, due largely to Mr. Hitchcock's antics. I think it's interesting that he refuses to give the report, but then cherry picks and quotes certain provisions in that report as part of his response for today's hearing. So again, kind of is what it is. I think just getting those results pursuant to Judge Hahn's order from last year is certainly kind of the center pin as to where we're at with this, and we need that prior to setting any trial dates or mediation dates or such. But that's certainly information the court has contemplated and been patiently waiting for the better part of 16 months. We're just simply asking that we enter some kind of an order that directs Mr. Hitchcock to, number one, cooperate, and number two, Dr. Maherg to issue those directly to us.
All right, thank you. Mr. Hitchcock, any response?
Yes. Yeah, I mean, I clearly showed me, Dr. Maherg said that I was fired when I resigned. And then he went on to say that I worked for multiple pediatric home health agencies when I've only worked for one. And that was just from his intake with me. The report can be released, but again, like, I mean, it is clearly biased. I mean, like, it's not accurate. I mean, just the fact that he's saying that I work for multiple companies when I worked for one, and I included that statement from the family that I work with. And that was just one thing I picked. I mean, there was a number of things that were just clearly erroneous with it. So if you want to release it, that's fine. But again, I am concerned about its accuracy because he said things that weren't accurate. Yeah, and Megan's always asking for money. I don't have any money. If you remember, before she moved to Utah, she said she had property there. Megan has already purchased property. She's left with $6,000 and around $6,000. And
Judge, I would just object to anything that's far outside the scope of the content of the motion today. I think we're getting way far afield of that.
You're asking for money, Chad, and I don't have money to give you. I have no money to give you.
All right, it sounds like, okay. If you disagree with the contents of the report, that's perfectly fine. That's the contents of the report aren't necessarily going to be accepted as, by the court as this is, the truth of everything. That's something that can be brought up at trial. That's something that you can question Dr. Maherg about. But it sounds like you agree that that report should be released. Right. I don't see a proposed order, Mr. Zandy. I mean, I can write a bench order up after court, or if you want to draft something and send it and I can sign it.
I think given the history of this case and the allegations that are constantly raised in some of and again, to use prior judges' term, frivolous motions and such that have been brought by Mr. Hitchcock, it's best just to preserve the record. So I think if we have a presentation date for 2 weeks out, at which time we can appear, you can sign it, and we can hopefully move on. I think that's probably the most prudent way to go.
All right. Does the 12th of December work for the parties? I'm
That's
open any of the December dates. Mr. Hitchcock, are you available the 12th at 1 p.m.?
Yes. And I would ask while we're here, my ex and Megan and Mr. Zandy's office have made it very difficult to do visits in Utah. I'm traveling over 1,000 miles. I've had to take additional time off work because they said I can't do 2 visits in 1 week. Every 2 weeks. Can you speak to that at all?
And again, I would object to anything that's outside the scope of the motion in front of you today.
Your Honor,
if there's a concern with your visitation and how that's happening, if you want to file something and we can hear that on the 12th potentially as well, we can do that. But what's before the court today and the information that I have before me today is in regards to the evaluation from Dr. Maherg.
Okay.
So we'll set it over to the 12th of December for presentation at 1:00 p.m.
And fees, you want to reserve those, or do you want to issue any specific amount? I'm
going to reserve on fees.
Okay.
So
and you want me to both parties cooperate to get those published as soon as possible pursuant to the order? Okay.
Yes, please.
Very well.
And
Thank you.
Reserving on fees, Mr. Hitchcock, means if there's something that you wanted to present to the court specifically regarding fees, you have an opportunity to do that before the 12th. I have, I'm going to start with a couple questions to the parties, if that is okay.
Yes.
And I apologize. I thought I made really good notes, and I always think I make really good notes. One of the parties indicated in their declaration that there's currently between, I'm going to say $250 and $450 a month of daycare expenses currently that's shared in the proportional amount between the parties at this point in time. Is that fair, that there's ongoing daycare expenses?
Yes.
Yeah.
Okay. And, but they wouldn't exceed maybe $500 a month at this point?
I don't anticipate it increasing more than it is right now currently.
No, and what would happen, I guess I would just point out that if the child is at St. Rose, they have before and after preschool daycare that wouldn't cost these folks anything additional. So from the time they open until I think 6 p.m., the child could go in, transition directly on campus into daycare at no additional cost.
And is that only for the days that they have school, or is that for every day of the week?
Well, it's for every day of the week, but if he's only enrolled in a 3-day full day per week schedule, which is what is proposed, then it would be whatever 3 days they enroll him in that.
And the other 2 days would be you're finding daycare somewhere else.
If you need it, yeah.
Okay. That
But
I just wanted to clarify that because if daycare was just available, period, obviously that would impact things a little bit more greatly than if it's just the 3 proposed days a week. Okay, thank you for answering those questions. I guess this is Mr.'s motion. So Ms. Bliss, if you want to make any argument.
Thank you, Your Honor, and I'll keep my argument brief. I believe my client's motion and reply declaration adequately laid out my client's concerns. For the record, I do represent Jordan Scrivener in this matter. We're before the court, obviously, to discuss whether or not Ren should be enrolled in school and or which school. My client lays out in his initial motion the various hurdles that he's had to overcome with Ms. Scrivener and her ever-evolving moving target reasoning as to why one school is not appropriate and why ultimately St. Rose is the only option that she's willing to consider. My client provides for the court that there's been 3 different schools that he's looked into. Obviously, first was the TK school at Lexington. My client provides that he looked into the school. It was 5 full days per week. It was free. It was directly right across the street from the daycare that Ren is currently attending. That the daycare attendee would transport Ren to and from school. That was the most feasible option for my client's position. That was denied by Ms. Scrivener first because she didn't agree that Ren should be in 5 full days of school. Then it turned into a claim that my client fraudulently filled out the paperwork. My client provides for you that he spoke with the school. He notified them that he was using his mother's address and it wasn't an issue. That issue with Ms. Scrivener caused the child's spot within TK to eventually be given to another child due to the delay in making a decision. Then turned into my client finding LCC Head Start that the parties had previously looked into, previously applied for, previously were denied due to their 2-parent income in their household. Now my client is requesting that the child be able to attend LCC. It's 3 half days per week, excuse me. It's free, which is a big issue that I'll discuss in a moment. And it's centrally located. So my client is asking that the child be allowed to attend that school. Again, Ms. Scrivener comes with various reasons as to why LCC isn't going to work. The first being that she didn't think that she would be approved. Turns out she was, because she does have food stamps currently. So that once that hurdle was overcome, then came an issue of, oh, I don't want him in 3 half days because I may be changing my hours, which I understand in her responsive declaration, she has changed her work schedule. So it's convenient timing, I would say, but nevertheless, the child's going to have to be in daycare regardless, whether he's at St. Rose. I get that there's daycare included at St. Rose, but there's a significant cost associated with St. Rose. You heard from my client and from Ms. Scrivener, my client doesn't utilize daycare. He's been on paternity leave for the last several months. In reviewing Ms. Scrivener's responsive declaration, she makes allegations that my client's violating the parenting plan by using his significant other to watch the child. He adamantly denies those allegations and has repeatedly refuted those by providing documentation showing that he hasn't returned to work. At least at that point, I do understand that he returned on the 20th, and that has been discussed between counsel. But up until now, he's been on paternity leave, hasn't had a need for daycare, and nevertheless, that's an expense of Ms. Scrivener currently, and one that my client is currently not required to pay because he's not utilizing those services. Nevertheless, my client provides for you that not only did he just return to work from paternity leave, his spouse or his significant other, excuse me, is still on maternity leave, is still not working. So there's a 1-income household in my client's home. He does have this newest child, Beckett, who was born in August of this year. And so his argument and what he's asking the court to consider is that requiring him to pay $500+ per month for a school that's not the only option. If St. Rose was the only option, my client would enroll this child in school. He understands that the child needs to go to school. He's been frankly pushing for this child to go to school. But to only pick St. Rose when there are free options out there, he's asking the court to consider that. My client is paying child support despite the fact that there is a joint residential schedule. So including a significant portion of his proportionate shares to be paid towards a private school is just simply something he cannot afford. If your honor is to order St. Rose, the child be enrolled in St. Rose today, my client will obviously have the child go to school, but he is asking the court that if you do order St. Rose, that you do require mother to pay 100% of those expenses, given the fact that she's denied every other free alternative.
Thank you. Ms. McLean?
Thank you. So first off, I would note that Mr. Scrivener's response now brings up a different school. I didn't hear counsel argue that. The motion is specifically to enroll the child in LCC Head Start. So I would ask the court not make a ruling as it relates to CVG. If you are considering something relative to CVG, then I would ask to be allowed some leeway to provide some additional input to the court. In regards to specifically LCC Head Start, the difficulty is my client is within the workforce, and it's not convenient that her work schedule was changed. She has no control over what her employer tells her are going to be her work hours. This is a single parent who, during the course of their marriage, was a stay-at-home parent. She is transitioning back into the workforce and trying to get more hours and be an independent financial support for her child, whom she has 50% of the time within her household. Mr. Scrivener argues that, well, I don't have sufficient funds within my household. He makes almost 3 times my client's income. He has a second individual sharing expenses with him. And I understand she's currently on maternity leave, but that's not going to be forever. And she has a good job. She has the ability to go back into employment and to also provide financially for their child together. So at this point, when you're looking at just the realities of finances for these folks, the suggestion that my client, who is bound to whatever her work schedule is and is trying to get into full-time employment, and now you're going to hamstring her with these suggestions. For example, LCC Head Start is a 3.5-hour program, 3 days a week. The problem with that is they have no before or after school daycare program. So these parties would then still be paying for daycare. They'd have to make sure that somebody could transport to and from. So let's say you put this child out in Faith Family who does transportation. You're looking at a cost that's much more expensive than it would be for this child to attend preschool at St. Rose and to have that daycare support to allow for, one, the child to be exposed to other children, to be in that education curriculum, and then also to have that daycare support if either of these parents need that, again, at no additional cost. The suggestion about the TK Lexington program, first off, educational decisions are a joint decision. Mr. Scrivener engaged the child in an evaluation with Lexington School, and it's outlined directly in his text message without even disclosing that to my client. She wasn't allowed to participate in that. She had no knowledge of that when he did that. He then comes to her and says, hey, I want to enroll in this TK program at Lexington. The application that was provided utilizes Mr. Scrivener's mother's address. That is not the child's address. If you look at the form that was filled out, Mr. Scrivener doesn't even identify my client as Ren's parent. She's completely left out of that whole scenario. When my client contacts the school, confirms where she lives in Rose Valley, confirms that, in fact, Mr. Scrivener lives in Longview, she was told that they wouldn't qualify, that they'd have to go through the boundary waiver provision through the school district. So what Mr. Scrivener is asking this court to do is to punish and essentially to punish my client for not engaging in fraud. And that, I think, sets a very dangerous precedent when we're talking about a child who's just getting involved in the school system. Parents have to follow the rules. And my client wants to make sure that her child isn't going to be blackmarked going further or moving further through school. So the TK program was not applicable to them. There was no boundary waiver request. My client lives in the Kelso School District. The child's school would be Rose Valley Elementary. Mr. Scrivener lives in the Longview School District. Apparently, the child's school district, although he didn't outline this, would have been, I guess, CVG. I don't know. He suggests that the stepchild goes to CVG. But that's technically not before the court. My client, for a year, has been saying she wants to get this child into school. There's an option where this child can be attending school through Rose Valley. Or I'm sorry, not through Rose Valley, through St. Rose. Look back to when this child was in daycare at We Care Daycare. The child was there consistently. These parties were paying more than they would be paying for St. Rose for We Care Daycare. The child had real difficulties. He was acting out. He was being aggressive with other children. He was being angry. Other children were being aggressive with him. There's a number of incident reports involving this child. And my client just simply feels at his age and level that he's not ready for full time like that. They had that discussion and they apparently have agreed that part-time would be appropriate. my client's mother works at St. Rose. So if you go to the attachment to Mr. Scrivener's motion, you'll see the cost for St. Rose. St. Rose for the 3 full days per year is $5,076. It's my understanding that they can pick whatever 3 days they want to have him in preschool, because they do provide preschool 5 days a week, that they do have that before and after preschool hour daycare provision at no additional cost. It's all covered in that $5,076 a year. And because my client's, excuse me, because my client's mother is an employee with St. Rose, they get a 20% discount. So when you take that $5,076 and divide it or times it by 80%, to give that 20% discount, that means that they would be paying $4,061 a year for the preschool and daycare support. His 72% equates to $325 per month. Mr. Scrivener, at least according to the current child support order, let me go back there. According to the current child support order, his net income is $4,730. My client's net income is $1,852. Ms. Bliss said that he's not currently paying daycare expenses. I'm not certain why, because if there's work-related daycare expenses, which my client has incurred, he's responsible for paying 72% of those under that existing order. So he should be paying daycare. And our position is that he should continue to pay for daycare and for the preschool at that 72% level. He's currently paying $250 per month in deviated child support. His basic support is $788 a month. So if you add the $325 and the $288, he's still well below that $788 basic support amount. My client just wants this child to have some school exposure, but she needs the support of having daycare. She does not have the funds that Mr. Scrivener has. So she's in that position where she is receiving food stamps. She's trying to get full-time. The suggestion that her work should be put on the back burner and not considered is not conducive to this woman being successful within the employment place and making sure that the child has sufficient income within her household. So our position is that the court ordered that the child attend St. Rose, that Mr. Scrivener pay his 72%. I note that he continues to say, I can't pay for this. I can't afford this. If you go back and look at the file, there's not one financial declaration submitted for Mr. Scrivener. There's no basis to support that bald assertion and claim by him. So we're asking the court to deny his request to order that the child be enrolled in LCC and order that he attend St. Rose. And quite frankly, given the disparities in the incomes, we're asking that the court consider a contribution towards my client's attorney's fees of $750.
Ms. Bliss, thank you.
Your Honor, just briefly, again, with Ms. Scrivener's ever-evolving reasonings as to why my client's proposals aren't appropriate. Now, the largest issue is she needs daycare. That would have been alleviated by 5 full days a week of kindergarten or preschool, excuse me, which was again denied by Ms. Scrivener. Ms. Scrivener claims that she has tried for a year to get this child enrolled in school. True. But her only option has been St. Rose, despite any other discussions between the parties about different schools, different options, different days, different times, different costs. St. Rose is her only option. And that's evident by both declarations of hers and my client and the text messages that have been provided. My client has tried endlessly to get this child enrolled in school, providing numerous options, free options that both of the parties can address and deal with. And Ms. Scrivener's only option is St. Rose, which is causing a significant financial impact on my client. My client is asking the court to deny the request for St. Rose, order the child be enrolled in LCC, which is a free schooling option, and deny the request for attorney's fees. Again, provided in the declarations, my client tried adamantly to get this matter resolved outside of court, but it was Ms. Scrivener's way or the highway. And that's why we were here today and why we were asking the court to make a decision.
All right. Ms. Height, I know that you did the GAL report and that was just a few months ago. I don't know. I did note, I reviewed it briefly in preparation for this, and one of the quotes from there is that Ren is embarking on a new preschool adventure that he's very excited about. I guess one of my questions, and you may not be able to provide any insight on this, or you may be able to. I did see the disciplinary reports from the daycare, 3 days versus 5 days. Any position on any of this that you would like to share?
Thank you, Your Honor. It has been a while since I've spoken with anyone in the family. That comment in my report referred to he was just getting into the facility that was just across from the Lexington school, and he was quite excited about that. I don't know that the difficulties that he encountered at WeCare daycare were related directly to how many days he was there. I think there were perhaps some difficulties in their staffing during some of that time that made some of those incidents not get dealt with permanently. So I think it's good that he's somewhere else. I frankly don't know what the correct option for him would be. For a child that age, I think half days are often easier for them to tolerate. And in some of her comments to me earlier, Ms. Scrivener had commented that she thought at that time, and it has been many months, that he would do well with half days or part days. So that's one consideration that could be put into the mix. But as far as the other things that you're considering, I don't have any helpful information, I'm afraid.
Thank you. Does that raise any questions from either attorney?
Nothing for me.
I guess other than Ms. Scrivener indicating she doesn't want more than 3 days a week for this young person, is there any other reason why he's not in 5-day-a-week preschool at this point?
No.
Well, other than my client isn't, I think she works 3 days a week. So as far as daycare, they haven't been able to agree on a preschool. So they don't need 5 days a week as far as daycare.
I understand that, but there obviously is a disagreement between doing 3 days a week versus 5 days a week. So is there any reason other than she just doesn't think that it's appropriate at this point? I mean, is that based on
the cost? I mean, again, if you're looking at St. Rose, if you look at 5 half days would be another $700 a year. They do 3 half days. But to be quite honest, I'm not certain if the half days, I'm assuming the half days have the daycare support as well. I'm assuming.
And if I understood Your Honor correctly, you asked if there was a reason as to why 3 days versus 5 days, and if there was any reason other than Ms. Scrivener outside of St. Rose and the cost associated. There was no reasoning other than her wanting St. Rose previously.
And perhaps so I guess the suggestion that my client is somehow some impediment to full-time, I guess my understanding is that cost, one, because he was objecting to the cost, and two, I guess as far as their respective schedules.
Okay. Her schedule though now is 4 days a week, isn't that correct?
I believe so.
Yes.
So even if we did a 3 day, so I guess I'm a little frustrated. So even if we did a 3 day week daycare, she works 4 days a week. There's still going to be 2 days of daycare needed on at least 1 on her week and potentially 2 on his week. Is that fair? So we're still going to have a daycare cost as long as there's a 3 day. Would that daycare cost exceed $700 additional for the year for a 5 day St. Rose program? Number one. Number two, frankly, it does appear that she's said no to every single option and that Mr. is the only one that's sought out other options besides St. Rose. And her response has just been consistently no St. Rose for varying reasons. This is, it's a little disconcerting that we're here on this type of an issue before the court. This child's 4 years old. There's going to be 14 more years of this if these folks can't get on the same page. I understand my initial thought was if there was daycare 5 days a week, even if you were only enrolled in 3 days a week, then St. Rose to me seems like a no-brainer because it would be a wash at best and maybe even to the benefit of the parties. If daycare is only available the 3 days that the child is in school, then we're still dealing with at least 1 day of daycare a week for the child, if not 2. So, and the parties are correct. I reviewed, it looked like it was a 72-28 split for any costs that are in the current order. And I did see, and I don't recall which declaration indicated that current daycare costs between X and X weekly on average. Ms. McLean, go ahead. What were you going to say?
So if you did the 5 half day, that'd be $5,760 a year. with the 20% discount, that puts it at 4608. His 72% on a 9-month basis is $368 a month instead of $325. And then you've got all 5 days covered. And my understanding, and I hope I'm not speaking out of turn, my understanding is that there is that daycare support, whether at no additional cost, whether it's a half day or a full day.
I found it. It's in your client's, Ms. McLean's declaration, and it's index number 46, Ms. Bliss, that the average cost currently per month is $350 to $425 for daycare.
Right.
And
that's the one in Lexington that's across from the school.
And that's the total. So there would still be the 28% split of that. So clearly both parties would be paying a little bit more for that for St. Rose versus the daycare. But obviously there's the schooling that's incorporated in that. And Ms. Bliss, you indicated, and I'm sorry, I didn't, of course, write this part down. His current child support amount is $788 or $288?
$250.
$250.
Correct.
Yeah, his basic support is $788.
But that's not what's been ordered.
No, it was deviated down to $250 for the joint custody.
Okay. Total obligation if the child were enrolled in St. Rose 5 days a week and kept
days or full days.
I'm sorry,
half days or full days.
I think half days are probably appropriate. If mom's concerned about 5 days a week, then I wouldn't want 5 full days. So that 4608 amount is 5 half days, correct? With daycare.
Discount. Yep.
Then Mr's total obligation a month for child would be $618. Here's what I'm going to do. I have nothing really that other than mom being concerned about it being an overwhelming for the child to go to 5 days a week. And I'm not suggesting that I know more than a parent does about their own child. That's not my suggestion, but we're already almost halfway through what the school year would be. And next fall, it's 5 years. I mean, Dad pretty much indicated that we got to rip off the Band-Aid at some point because 5 days a week are happening soon enough. So I think this is what I think is appropriate. I think St. Rose is with the addition of daycare, I think 5 days a week, half days is appropriate. If there's a problem and that's overwhelming to him, then I think that's something that we can, hopefully the parties can work out, but if it needs to be brought back before the court and we need to go to 3 half days. But frankly, I think 5 half days with the benefit of having daycare to the parties at no additional cost. I understand that it would increase Dad's obligation, but from what I'm looking at with an average of, if we average out the costs of $375, he's still paying up to $300 a month in daycare as it is. So the $250 plus $300 puts us at $550 for $618. You get school on top of it and daycare. To me, that's not a drastically higher request. So I think we should attempt the 5 days a week for half days at St. Rose.
So if you're working off of my proposed order, if you go to 6A, you could just change the second line where it says 3 full days, change that to 5 half days.
I'm not going to authorize any attorney's fees for Mrs. on this, so I'm going to strike any judgment against
1 and 5.
Yes, against the petitioner in this case. I do think this is, I'm worried this is going to be an additional concern. And I'm going to just express this right now. I commend father for seeking out options, especially free options. I don't want this to set a precedent for mom to think that, okay, this kid's going to be in private school the rest of the rest of their life. I don't think that's appropriate. I think, frankly, crunching the numbers, doing this 5 days a week with the opportunity of daycare for the child is pretty comparable to what the amount of daycare costs that are currently being incurred and would continue to be incurred through the remainder of this school year. So my hope is the parties can figure out a viable option for the child next year when they start kindergarten. I don't think that the respondent in this case should assume that because she frankly got her way in this motion that that's going to be how it goes the remainder of the child's educational career. So I just wanted to say that.
I'll relay that to her, and that's not my understanding of how my client operates.
I would, but I do want Ms. Bliss you to commend your client because I think he really did. I don't think he did anything fraudulent. I did note that he did not list mom's name on that TK application. I don't necessarily think that was anything nefarious. And I don't think that there was any fraudulent acts. The same way Ms. Scrivener wants to use mom's discount for St. Rose, dad wants to use mom's address to get into a different program. That all makes sense to me. I don't think that there was anything wrong there. Ultimately, I think we're talking about 20 or 40 extra dollars dad's going to be paying out for a St. Rose program when he was already paying almost, it's $368 for 5 half days at St. Rose, including daycare. And he was averaging paying about $325 if I use the numbers that were given. So I guess about $50 extra a month for everything. So that'll be the order.
Your Honor.
Yes.
When I did my investigation, I recollect that Mr. Scrivener left for work very early. I think he has to be in Winlock, if I recall right, like at 7 a.m. And I wanted to make sure that it was going to be okay for his fiance, soon to be his wife, to transport, or a grandparent to transport. I know there's been some difficulty about some of that in the past, but
that's not something that's currently before the court. Perhaps we can discuss that if that becomes an issue.
I would hope that mom would be willing to work with dad about ensuring that their child gets to school without that being a major issue. But I appreciate that, Ms. Height.
Thank you, Your Honor.
All right. Good luck.
Thank you, Judge.
Thank you.
Good afternoon, Your Honor.
All right. Well, this is a pretty interesting situation that we found ourselves in here. So we have currently what it shows is we're on for 3 different show cause contempts, but I know that there was a motion regarding the default that was supposed to be passed along so we could line up everything. Both parties responded to that. I'm assuming we're all comfortable knowing that. Okay. Because on the docket, it shows the contempts. So
and I saw that as well. So my understanding is we're on for Mr. Hunter's motion to vacate and then our motion for contempt, and that's it. Is that your understanding?
that is my understanding.
That's my understanding as well.
Okay, great.
Okay. All right. I'm going to start with you. Obviously, I think the default issue probably takes precedence in my opinion. So let's start there. So I'll defer to you, Mr. Hunter.
Thank you, Your Honor. I'll keep points kind of minimal here. I think everything that we filed it contains the bulk of our argument. So just make some one clarification. Mr. Cutler's grievance with the state bar was filed on February 28th, not the 8th, and that can be shown in our letter from the state bar. That's Exhibit 5 to our motion to vacate. It states that the grievance was filed on the 28th. I think Ms. Roush got the 8th from my memo, which was a typo.
The 8th of February, so same month, just different day. Okay.
Same month, just different days, right? So I just want to make that clarification. And just as a reminder, the rule here that we're arguing for is CR 60B11 and the case law of Barr v. McGugan. I think that's how that's said. And the rule here is that an attorney's actions cannot be attributed to a client when the attorney-client relationship is disintegrated to the point of no practical representation. And specifically in Barr, one of the controlling factors is that the attorney had suffered from a mental illness that had a major impact on their ability to represent the client, as well as a breakdown in communications, even though the client was diligently following up. And here, Mr. Cutler was completely unaware of Mr. South's mental illness. I apologize if any other attorneys on there. His attorney's mental illness was not known to him until his previous attorney filed a response to his grievance. That was the first he had learned about it, and that was the first time we had realized there was some actionable claim to set aside the final order. Petitioner even acknowledges that Mr. South was completely unaware of the status of the proceedings. Petitioner acknowledges that Mr. Cutler's previous attorney showed up to a trial thinking it was a hearing on a default. And that's also what Mr. Cutler claims as well. He was completely unaware about what was going on in the status of his case, despite reaching out, getting feedback from his previous attorney, and basically getting the wrong information. So he was diligent. He was completely unaware of what was going on, and it negatively affected him. So, and briefly in response to petitioner's memorandum, they rely on the case law of Stanley v. Cole to show that Barr was not a controlling factor in a case where Stanley had the attorney did not show up for an arbitration hearing. I really want to point out in the Stanley case, the court in that case specifically noted the number one reason they did not follow Barr was because Stanley did not plead for relief under CR 60B11. That's sort of the catch-all of CR 60. They specifically said that's the number one reason we're not following Barr. And because Stanley presented no evidence that the attorney had suffered any kind of mental illness. And finally, with regards to the Cutler case having not been heard on the merits, or being heard on the merits, I think petitioner is trying to state that a one-sided trial is a trial on the merits. The same court that issued the Barr decision issued a decision in re the Marriage of Layman, and that's number 33868-1-Roman numeral 3. That was decided in 2017. In that case, the court stated that under Barr, they do express their desire that cases should be decided on their merits. And in a footnote to that sentence, the court goes on to say that we desire, and this is quote, we desire cases to be decided on their merits so that a finder of fact can declare what is true and the law can produce a just result. When an attorney substantially fails to present his or her client's facts to the finder of fact, truth is in doubt, and so is the result. So essentially, just to make it brief, Your Honor, we think Mr. Cutler's position falls squarely within the Barr decision, and it should be upheld. The same, the motion should be vacated, and a trial should be held. Thank you.
Thank you, Mr. Walker.
Oh, Mr. Hunter. Sorry, I don't want to. Mr. Hunter. There's two Brians at our firm.
Oh, did I say Walker, Mr. Hunter? I apologize. Thank you.
Yeah.
Ms. Rush.
Thank you, Your Honor. So obviously we disagree, and I know you've read the materials, but I'll just kind of briefly go over them. And I know Your Honor's familiar with this case, having heard some of the motions. What we're operating under here, just as a reminder to the court, is there was not only a motion in default that was granted, there was also a motion in limine that was granted that basically said Mr. Cutler was precluded from presenting any evidence or testimony at trial. So those were granted, I believe, in January of 2023, right before trial. And subsequent to that hearing, the next day, Mr. South appeared at readiness for trial. So that's one really important distinguishing factor from Barr, is that in Barr, the attorney had completely kind of disappeared, was not participating, didn't have anything to do with the case. In our case, Mr. South appeared at readiness. He appeared at the trial. He indicated on the record multiple things about the case if you look at the clerk's clerk's minutes. So that's very distinguishable from Barr. In addition, in Barr, there was no trial heard on any sort of merits. Mr. Cutler's position is that because his side was not allowed to present any evidence that there was no trial on the merits here is inaccurate. My client, to be fair and to cover all of her bases, presented testimony. She presented witness testimony by an appraiser. She presented appraisals. She presented multiple financial documents under ER 904, which were then subsequently admitted at trial. So this was not a case where we just showed up and the court said, default granted, you get what you want. My client, out of abundance of caution for this very reason, put on a prima facie case to establish value specifically and to tell the court what her preferred allocation of assets would be. In addition, in Barr, there was a proven record of long-term depression that impaired the attorney's ability to practice law. What we have here is we have one statement from Mr. South, apparently in response to a Barr complaint. And I will note that my office reached out to Mr. Hunter asking for the complaint that his client made, because I would like to see the whole correspondence. We didn't get that. So what I have from Mr. South to the Barr, and this is, and with all due respect to Mr. South, this is an attorney who's trying to protect his bar license, is my mother passed away. I suffer from depression. et cetera, et cetera. That didn't inhibit his ability to practice on this case for the 3 years leading up to trial. So unlike bar, we don't have this long-term, where long-term impairment. We might have had a situational impairment, and that's why the trial got set over in September. That's why he could have asked for a set over in January. And that leads me to my next point, which is my client is not the one who should suffer here because of this. My client is not the one who should face a hardship because of Mr. Cutler's position. Basically, Mr. Cutler's recourse is against his attorney. And that's very solid. The motion to vacate, one of the things that is very clearly stated in the bar case is that the court cannot vacate if it's going to cause a substantial hardship on the non-moving party. This would cause a substantial hardship on my client, who's already expended tens of thousands of dollars in attorney fees. She's already been declared single by the courts. There are taxation issues. There's a whole host of issues going from divorced to back to being married could have. It would cause her to incur additional attorney fees, which she's had to do to defend against this exact motion. So in looking at just a couple other points that I'll point out for the court, the other remedies that were available to Mr. Cutler is he could have appealed the final orders. They took no action on this for 6 months after final orders were entered. They could have sought reconsideration or something of that sort at the time. The time that lapsed doesn't make sense to me or my client. If they knew that they had an alleged issue about Mr. South, we don't understand why it took over 6 months from when final orders were entered to do something about it. Less than a week before filing this motion to vacate, Mr. Cutler had been in correspondence with various people recognizing the validity of the decree and offering solutions on how to adhere to it. So less than a week before filing a motion asking that this court to set aside the decree, he was recognizing that the decree was valid and was trying to make payment arrangements. So I think, the case law is pretty clear that relief is to be granted sparingly. That's very clear in the case law. He filed for relief under CR 60B11, which is the catch-all provision. There's no request for relief under any other section in that rule. And I think that is pretty clear as well. Finally, in this situation specifically, Mr. South's actions are attributable to Mr. Cutler. Mr. Cutler would have you believe that he was a diligent client, but that he had no idea what was going on with his case. That's just not accurate. This really, there was a singular issue where he missed a hearing. Mr. South missed a hearing on the default and the motion in limine. But then the next day appeared for readiness, appeared for trial. So we don't have the situation like in bar where the attorney basically disappeared. And I think that's an actual quote from the case. We just don't have that here. And so basically what should happen is the decree should stand. Mr. Cutler has recourse against his former attorney. My client's not bringing this defense forward to be insensitive, but my client put forward an appropriate case. As we put in the record, she didn't take a default and try and run away with it. She really tried to put on what she thought was an appropriate division of the assets. And my client just wants the divorce to stand. I'm happy to answer any other questions that Your Honor has about this. I'm just looking at my notes to make sure I covered everything, but I think that's it for now.
If I may respond, Your Honor.
Yes, go ahead. Thank you.
Just a few quick points. I'll just reiterate that Mr. Cutler's previous attorney did indicate that for 3 years he'd been caring for his mother and had been suffering with clinical depression for years. As for the appeal or reconsideration, I understand Ms. Rush's point. I actually would concede that moving with a default motion in limine in the trial is the appropriate activities to go on. In fact, the reason for the lapse in bringing a motion to vacate is largely because the general rule is a client is held to the actions of their attorney, even if it's negligent or wrong. It wasn't until Mr. Cutler learned that his previous attorney suffered from severe mental illness. It suffered from depression. This put it squarely within case law that opens up for a CR 60B11 motion to vacate. So the 6 month delay, that's the reason. He found out, and it was late August by the time he had learned of this depression, and this has never been disclosed by Mr. South before. This is in Mr. Cutler's declaration. That's the reason here. And we would agree that I think an appeal or reconsideration would be inappropriate because I believe Mr. Rauch followed the steps appropriately. I didn't really see any problems with moving for a default or motion in limine in a trial. But what we're saying here, the basis for this motion is simply because of the mental illness, because of the lack of communication. There is a reason that Mr. Cutler essentially was completely unrepresented when he thought he was being represented. Thank you.
I do have a couple questions. So do you have, and it sounds like Ms. Rush requested this of you, Mr. Hunter, do you have the initial complaint that was filed by your client to the bar?
No, Your Honor, I do not have that. I have Mr. Cutler is here with me as well. If you'd like, I can confer with him on it. No, I do not have that complaint.
Is that something that he has a copy of that he could provide to all the parties?
We could do that, yes.
Okay. Second thing, and this is just I'm going to throw out a hypothetical. If, is this a scenario where if the court were to grant respondents' request on the default, could it be bifurcated in a way that leaves the parties' marriage dissolved, but brings back into so essentially it doesn't we leave the dissolution in place and just readdress the property issues, because that's frankly the money and property seems to be where the concern is. And I know that you may not be able to answer that question. It may be an absurd question, but in listening to Ms. Rush, there's clearly, I mean, 6 or 7 months have gone by since the default was entered. And I cannot imagine what the implications would be for, frankly, either party to be acting, and the tax implications, all the things, to go back and say, okay, wait, nope, we're actually still married for the last 6 months. So I don't know if that's something that could be parsed out. I'm just throwing that out there.
Thank you. I had that same thought fairly recently too. I think we could all agree that Mr. Cutler doesn't want Ms. Weiss to go back to being married. It's not clear to me if we were to change the final order. One thought I had kicked around is if the order was changed to say reserved on property, for instance. But I think what that does is creates a modification of a final order, and that's not properly before the courts. So, unless Ms. Rush was willing to stipulate to it, I think it's, I'm not aware of any legal standard for piecemealing the undoing of a final order. I defer if Ms. Rush has any idea.
And I don't believe you can, because if you vacate the order, you vacate the order. And that's the entire order that says the parties are divorced. Here's the property division. So I don't believe you can.
Okay. Thank you. And that was before taking the bench. My primary area of practice was not family law, so I've learned a lot in the last 5 years. But that this is kind of a new situation. I do very much appreciate the memorandum, Ms. Rush, with the case law. Initially, my thought was.
Your Honor, I may have one more point my client just reminded me of. I apologize for the mention.
Sure.
There, another option, perhaps, item 20 of the final order. This came up in the contempt motion. Mr. Cutler's attempted to refinance his properties. Item 20 has been a concern. And the reason for that is because he has a very particular program that he can go through to refinance. These are FHA loans for his Dusty Drive property. I believe it's the one, because it has a mobile home on it. So FHA is the reason he has to go that vehicle. Conventional lenders don't like to deal with mobile homes. So the reason I bring it up, in the alternative, if the order cannot be vacated, the parties may be better suited if item 20 could be changed to allow for payments towards the judgment, because FHA will allow judgments on a decree if it's allowed to be made in payments. But if there's a one-time judgment, like a one-time payment that could create a lien, they don't want to touch it. So it's not a great solution. However, it might be a better vehicle. So I just throw that out there for your honor.
I don't know. I'm assuming, Mr. Rush, that might be the first time you're hearing of that.
Yeah, I mean, if they certainly, we've had some correspondence in my office and another attorney's office about enforcing the judgments. I mean, if they want to make an offer about how to do that, that's one thing. But I mean, I think that removing my client from liability and getting her paid what she's owed under the decree is we could go there, but I mean, I think that's separate from what we're discussing right now. I appreciate that Mr. Hunter's trying to be creative, but I just don't think that falls, I don't know number one, I mean, I don't think the court has the authority to order that, but certainly if, depending on the court's ruling today, or if the court's going to take it under advisement or what have you, if they want to make us an offer, we certainly will review it, because my client certainly doesn't want to continue to litigate. She'd certainly like to be done with this, but she also feels that obviously she has judgments that she's entitled to receive. So,
and I would just state that's what I propose does not change the judgment, the money judgment as it is. It would just allow for payments, which under FHA lending rules is permissible. So it's not the judgment would still be there. It would just give Mr. Cutler an ability to refinance. where there currently isn't one. So, and that's assuming if the court chooses not to vacate the order. So just to clear that up.
Okay. Because these contempts are attached to this issue, and I'm going to let the parties know that this is, I am going to take this under advisement, but I do anticipate being able to have a relatively quick turnaround. I don't know if you want to make your arguments on the contempts now, or if you want to wait for a ruling from the court to address the contempts if needed.
Well, Your Honor, I mean, I think the contempt issue is fairly clear. I would defer to your Honor on that. If you want to make a ruling just based on the pleadings, I'm fine with that on the contempt, because like I said, I think it's, about kind of 5% of what we're dealing with here today. So, and they do go hand in hand.
Anything, Mr. Hunter?
I would agree. And if we're going there, I would just make a few quick points on the contempt. Petitioner agrees. Mr. Cutler is trying to fulfill the judgment. He's trying to, balance his other responsibilities to family and make the offer to make payments to petitioner, which we haven't received any response on. So, in terms of contempt being a, willful violation of a court order, he's trying to comply. He's running into various obstacles, but he's attempting. We just hope the court takes that into consideration. Thank you.
Okay. And Your Honor, I would just comment, if we're commenting, that he didn't provide any proof really of what his attempts are. Normally in a situation like this, you'd see a letter from a lender, you'd see a letter from the bank. I realize he filed that profit and loss statement, but we provided a breakdown of how that actually shows he's ahead of prior years. So, like I said, he may say, I've been making efforts and I have these family issues. Well, that's not relevant to contempt. I mean, you have a court order to meet a deadline, you didn't do it. That's just a fact. And so, while my client, again, is not trying to be insensitive here, it's very clear cut to us. So, she could have, quite frankly, after the 90 days were up, she could have marched into court with a motion saying, I want to force these properties to be sold. She didn't. She gave him a significant amount of time, more than he had under the judgment. So I think that's relevant too, just to show that she's really trying to work here in good faith. And that, like I said, we didn't receive anything for like 6 months knowing what was going on. So I appreciate he says he's trying. We just haven't seen the proof of that in the record.
Okay. Here's what I'm going to do. I'm going to set this for the 12th. So 2 weeks from today. My aim is going to be to email a ruling prior to that to the parties. And it may, depending on my time, I don't know what my schedule next week looks like, that either be an email just kind of outlining what I'm going to do, or it could be a formal ruling that I'll file with the clerk, and I'll obviously let the parties know what that is. My hope is that you'll have that at least a few days in advance before the hearing on the 12th. That'll obviously have the ball rolling one direction or the other as far as the contempts. And obviously, if there's negotiations between now and then, that if parties are free to continue any discussions. I would ask, though, that Mr. Hunter have Mr. Cutler provide a copy of the initial bar complaint to Ms. Rush and to the court.
And any subsequent, if there's been subsequent communication with the bar, if we could get that as well. All I've seen is the one letter from the bar to Mr. South, and then Mr. South's response back.
Subsequent communication from Mr. Cutler. Is that what you mean?
Just any communication on the bar grievance, I think, would be helpful.
Sure. And I don't know if you can do that, Mr. Hunter, or have your client get that to you and you get that to us by the end of this week. That would be very helpful.
I think we can do that. Would you like me to submit that to your JA, Your Honor?
Sure, that's fine.
Okay.
And then if we need a copy to be filed, we can worry about that later. But okay. I want Ms. Rush to have it. I'd like to be able to review it as part of my ruling as well.
Understood. We can do that, Your Honor.
Okay.
All right.
All right. Thank you all very much. We'll see you in 2 weeks. A few
different
issues.
Thank you.
We have a motion for visitation transition. We have a summary judgment. We have a motion for adequate cause and temporary orders. I'm going to start with the summary judgment. I don't know. I understand the adequate cause is going to come into play, but the motion to move has been stagnant. Ms. Green, is there any concern with that that move being granted on a permanent basis at this point?
No, Your Honor. I did email to advise you last week before the holiday that there would be no objection to the summary judgment. The only change made to the prior parenting plan was the location of the exchange. So we have no objection to finalizing the relocation on that issue.
And was the change in exchange location, was that agreed, Ms. McLean?
The current exchange. So I'm sorry, I guess I didn't see an email from council suggesting that they were agreeing to this summary judgment. So I will go back and look at my emails. The Judge Hahn ordered that the parties are to exchange at county line. And that's what our proposed parenting plan does.
Is that agreed, Ms. Green?
Yes, that was the temporary order. That was the only change.
Okay,
So
so
I would have,
sorry.
that's okay.
I have an order granting motion for summary judgment that was submitted by Ms. McLean, outlining that we were all present, that there what was considered, that there's no material fact exists as to any issues related to the relocation, that the minor children have been allowed to relocate on a temporary basis, and that they shall be allowed on a permanent basis, that they attend the Wahkiakum County schools, and the visitation exchange location be County Line Park. So sounds like that's agreed at this point. So I'm going to sign off on that so we can knock one of our 4 things off the list here. So we have a lot of cross motions here. So we have Mr. Hansen's motion for the transition of visitation, which was allowed for in the parenting plan that was entered last year, I believe. I think it was, I'm thinking August of last year, but maybe I'm making that date up, but I know it was 2022. And I think the August of 2023 was the date where he could move for additional or the final transition to the kind of 50-50 plan that was contemplated. We also then have a temporary order and adequate cause motion by the petitioner in this case, essentially asking that the court reconsider the parenting plan that was put in place. That's part of the motion, the transition motion. So I don't know. All of it is kind of intertwined. I believe Mr. filed his motion first, so I guess I'll start with Ms. McLean and then bounce back and forth here. So if you want to address all of it at once, if you want to just address your motion, I'll defer to you.
Okay. So I guess starting first off with the motion for the transition on the visitation, the final order parenting plan adopted that the parties were joint custodians. His current visitation is Friday to Wednesday every other week. And it was agreed that the visitation would transition to a week on, week off, with the exchanges occurring on Fridays for the 2023-2024 school year. And if that hadn't occurred by August, then my client could file the motion for enforcement. If you go back to Ms. Day's guardian ad litem report, she had suggested transitioning to the week on, week off in 2022-2023 school year. And she also recommended, and the parties adopted, a week on, week off visitation schedule during the summers. It was negotiated and agreed that the transition would start this school year. And then, of course, we have all of this blowback now from Ms. Hansen with these ongoing motions and now her new petition. Clearly, it was contemplated by the parties and agreed that the transition would occur because the language is in the order. It was agreed and memorialized that my client could file a motion if she wouldn't allow the transition to occur. And we are here asking that the court order that transition to occur. As I noted, the children have exercised the week on, week off schedule for the last 3 summers. There has been nothing that has been brought up or outlined about the concerns relative to those week on, week offs during the summer. And according to my client, those have gone well. Both parents are involved in their schools. We've provided communications that he's had even with the teachers now that the girls are in Wahkiakum School District. Both parents are involved in doctor's appointments, counseling appointments, extracurricular activities. We provided copious amounts of evidence to support that my client, contrary to Ms. Hansen's claims, is a very involved, loving father, and that he does have a loving relationship with his children. Mr. Hansen also has primary residential placement of his oldest child, and she is the girls' half-sister. And Mr. Hansen outlines for you that basically he has a week on, sort of an on-call week and an off-call week with work that was also incorporated in our plan. So we are asking to allow for the transition. We feel that that's going to provide for consistency for the girls. They will be able to know that every Friday they're going to go to the other parent's house. That will give them the weekend to transition and prep for the school week the next week, rather than having this exchange on Wednesdays in the middle of the week. And again, this was all contemplated by the parties that this would happen, that it was an appropriate thing as recommended by Ms. Day. I am going to at least go in, if the court's okay with discussing the adequate cause, because some of that also dovetails into the transition claims. First off, I would note that the order that you entered earlier this year outlined, and that was your September 6, 23 order, outlined that Ms. Hansen at that time had not complied with RCW 2609-270 that requires the court to make a prima facie determination for her filing a petition to modify the parenting plan. The statute specifically indicates, and that order indicated, that she has an obligation to submit her documentation to the court for the court to make that prima facie review and for the court to issue an order to show cause if the court finds there's been that prima facie standard met by her filing. That still has not occurred. Her initial filing that you heard in September was filed as a motion, which is not allowed. The current filing is under a docket notice. So they have again skipped over this court's ability to make that initial determination on whether or not they've met their adequate cause determination. And I would submit that the court should find that they have not. And I am going to outline the concerns relative to Ms. Hansen's credibility. I would note that in the most recent responsive documentation and throughout her and her witness declarations, there is ample child hearsay references. I would object to the court considering any child hearsay references unless there is a clear indication of factors that would support the court considering that. Ms. Hansen, we're asking that the court ultimately dismiss today's hearing, both for non-compliance with the statute as well as for no finding of adequate cause. The primary purpose of the threshold adequate cause hearing is to prevent useless hearings. And if you went back to my memorandum that was filed in response to the motion that was filed, I had outlined the Lemke case, which is 120 Washington at 536. After reviewing the history of the court, this case history, we're asking that the court take a look at the conflicting statements that have been submitted and conclude that these are simply petty issues that are being raised by Ms. Hansen. The standard on a major modification, which is what she is asking for, is for the court to transition from a joint custody parenting plan to a parenting plan where she's named the sole custodian. Ms. Hansen has the burden of proving that the children's joint custody placement with their father is detrimental to their physical, mental, and emotional health, and that the harm likely to be caused by changing the joint custody parenting plan is outweighed by the advantage of the change to the children. And the case law clearly indicates that custodial continuity is preferred, and we ask the court to maintain the joint custody parenting plan and transition to that week on, week off. If the court goes back and looks at Ms. Day's guardian ad litem report, it is very thorough. She's a very accomplished guardian ad litem. She's been doing this a long time. And when she completed her report, there were absolutely no findings or recommendations for additional services for Mr. Hansen. There was no finding for domestic violence, abusive control, abusive relationships with his girls, abusive relationships with other women. None of that came about. Ms. Hansen's original proposed parenting plan that she filed on September 17th of 2020 for the divorce didn't request any limiting factors on Mr. Hansen. The agreed final parenting plan that was entered on February 1 of 2022 had no limiting findings against Mr. Hansen. But if you take a look at paragraph 14I within that final parenting plan in 2022, you'll note that there are 5 factors that are against Ms. Hansen and her behavior. Ms. Hansen had undergone an evaluation with Dr. Maherg, who concluded that she resorts to manipulative, coercive behavior to have her needs met and or that she has fragility in her coping skills. Dr. Maherg stated that Ms. Hansen overexposes the children to adult information without comprehending or considering the effect of such activity on the young children. Dr. Maherg indicated that any mental health exacerbations or concerns should be reviewed by the court for further orders. And those are all encapsulated both in Dr. Maherg's report, in Ms. Day's report, and within those 5 factors that are outlined at paragraph 14I of the final parenting plan. Ms. Hansen, when she filed this relocation, her relocation notice indicated that the final parenting plan should not be changed. When Ms. Hansen filed her response to my client's objection to the relocation, she again said the final parenting plan should not be changed. She made no claims about any concerns relative to Mr. Hansen's parenting, and she has filed nothing to support a finding of domestic violence. Our concern is that Ms. Hansen continues to engage in the same behavior that was identified by Dr. Maherg. Ms. Hansen is not in my client's household. Ms. Hansen does not directly observe my client's parenting and relationship with his children. She relies upon hearsay, and obviously children are going to tell their parents what they think that they want to hear. They're in a position of power. They want to please their parents. And given Ms. Hansen's history of over-involving the children, we're concerned that that's exactly what's happening again. There are copious amounts of evidence that we've provided regarding outside sources that indicate that Mr. Hansen is an involved father, including the text from the teachers, the records as far as his involvement in counseling with the girls and within the family counseling between he, Ms. Hansen, and the children. Declarations from individuals and photos showing him being involved with his children, cards and terms of endearment that are expressed by his children directly to him. Ms. Hansen continues to sling false allegations, declarations, and information to the court to support her position. And the bottom line is she wants custody. She wants him out. She wants to be solely involved with these children and get him out of the picture. I think the fact that all four are involved in family counseling is a positive thing. I'm hoping that that's going to increase her ability to communicate with Mr. Hansen in a positive manner. Ms. Hansen continues to suggest that, for example, Ari was hit in the face by my client and that Ari was crying to her and said that she was hit in the face. And yet in a counseling session, she told the counselor she was not hit by her father in the face. If in fact she had been hit in the face, we would see a police report, we would see a CPS report, and there is nothing to support any of those claims. Ms. Hansen claims that Mr. Hansen is domestically violent, and in her reply declaration now, for the first time, she suggests, well, go back to Brittany Dominiquez, I think is how you pronounce her last name. Brittany is the mother of Mr. Hansen's oldest child. She said, Ms. Hansen says that Brittany made a claim of Mr. Hansen being domestically violent. I would ask the court to go back and look at Brittany's declaration that was filed in this court action back on October 5 of 2020. She does not support a claim that Mr. Hansen has in any way been domestically violent with her. They have always worked well together as it relates to their child in common. And she actually goes out to outline that, in fact, the difficult individual in the relationship was Ms. Hansen. So I would submit that you have direct evidence from 3 years ago that directly controverts a sworn statement by Ms. Hansen under oath. Ms. Hansen wasn't there for Brittany and Mr. Hansen's relationship. She would have no firsthand knowledge to make such a claim. She goes on to make a claim that about a declaration, I think, from Sierra Baker, who is her sister. If you go back and look at the guardian ad litem report, and I think it's page 4 or 5 of Ms. Day's guardian ad litem report, she talked to Sierra Baker. Sierra Baker specifically indicated, and I'm sorry, this is page 4, lines 16 through 28. She says, Ms. Baker is Ms. Hansen's sister. She says, Ms. Baker indicates that they lived with the family, that she lived with the family for a period of time. She lived with the Hansen family. Her quotes in Ms. Day's report are, they're excited to see their father. She has no concerns with either home or parent. That's the conclusion from her own sister who lived with them as it relates to the sufficiency of this father's relationship with his children. I would submit that there is ample evidence to support a finding that Ms. Hansen lacks credibility because she's on a mission. She has a goal in mind. She's trying to throw every potential conceivable allegation out there to see what the court will rely upon. But again, look at the history of this case. She's made none of these claims until September or August when she filed her motion. None of these claims have been made during the divorce that my client was domestically violent or that he was involved inappropriately with the children. And the counseling records support that the children see him as a safe individual and someone that they want to be involved in. So we're asking the court to deny the adequate cause request and her request for temporary orders. We're asking the court to order the transition. And quite frankly, when you look at the contrary evidence that directly disputes her claims under penalty of perjury, we think that the court should enter a finding of bad faith. And under RCW 2609-260 subparent 11, assuming you make a finding of bad faith, my client should be awarded 100% of his attorney's fees and costs for having to respond to this motion that was, again, for a second time, brought inappropriately before this court. Even though the order that you entered on September 6th clearly set out what that roadmap is, and the statute is clear. So we're asking the court to grant the relief that we've requested.
All right, thank you, Ms. McLean. Ms. Green.
Yes, Your Honor. So I will speak first to the request to exclude certain evidence. Regarding the hearsay exceptions, it's clear that there are allowed exceptions under ER 803 for present sense impressions and excited utterances. The majority of the statements made by the children were under duress, under trauma, and those statements should be considered for that purpose. In fact, it's kind of interesting that father doesn't want you to include mom's statements the children have written about him, but provides in his own evidence pictures and written statements the children have made in his home, trying to show that he's a good father. So I'm not certain why the exception would apply for father's evidence, but not mother's evidence as regarding the children's statements. So we are asking that all that information be included, especially the information that was provided by the children directly to the school or they created on their own without any encouragement from either parent while in either parent's home. Those should be the most important factors, as the children aren't under pressure or impressions to make a statement for the children or for the parents' benefits. So we are asking all of those be provided and considered. Regarding the order to show cause requirement for adequate cause, I was not present in an appearance of the prior occasion. I know that it was heavily disputed on whether or not, because the relocation action reopened and reactivated the case, whether or not temporary orders could be presented. I believe that you made a finding that it was not appropriate to go beyond what the relocation matter was. And so my client has properly filed and cited on a petition, properly had Mr. Hansen and his attorney served by a process server with personal service to make sure that this would move forward in order to have all these matters heard at the same time with father's request to change the parenting plan, because his request, yes, is in the agreed parenting plan, but in the year and a half that that parenting plan has been in place, it was actually entered, I believe it was February 1st of 2022 for clarity. There have been a number of situations and things that have changed, especially since father's visitation changed in February of 2022. So we are asking that the court consider the petition for modification, consider adequate cause and the temporary orders at the same time, given the consideration is related and relevant to father's action to change the parenting plan as well. It is in the judicial economy's best interest to hear all these matters rather than forcing a recitation, another hearing on the same issues yet again. So we are asking the court consider all those matters together because that is why we're here. The issue on the reply declaration, I do want to state that Mr. Hansen did fail to follow court rules. He does exceed the page limits on his reply declaration. He specifically states he's exceeding the page limits, and rather than referring to LCR 88C, which requires a motion be provided ex parte with notice to opposing counsel, he instead asked for leave of the court to exceed the page limit. So if we're going over protocol and procedures, the court has to consider all those factors, not just, it's not one-sided as far as following procedures and practices at this point. So so from this point, I will go into the meat of our motion and materials. The big issue that is being brought up is that for a father's motion for visitation transition, the agreement in the parenting plan says after August 2023, if the parents have not transitioned to exchanging the girls every Friday for visitation as recommended in the guardian ad litem report, then father may expand his visitation. It specifically says if they cannot agree to do so, then he can motion. It does not say that the court should not consider the children's best interest at that time. It does not say that mother can't object to it. And that's why we're here, because at this point, my client objects because there has been a substantial change in the children's behavior, well-being, conduct, and actions both at home and in school that have happened since the February 1st, 2022 parenting plan has gone into effect. At this point, there are a number of declarations, statements from the children, and if the court is considering all that, I'll go into some of the specific details. In fact, it's father's records that provide some context for this. He provides the Columbia Wellness records for the daughter. In his statement, he's claiming that the issues the children are having with transitions are related to their change to school. That is misleading the court. The records state that the meeting with Ariana and the Columbia Wellness counselor for her initial assessment occurred May 24th, 2022. The children did not transition or go to school in Waukegan until August, September of 2002. In fact, February 2022, the children were still in Cowlitz County. Mother was still in Cowlitz County. The change and notice of relocation was given to father June 28th, which is a month after this initial assessment. And his objection was filed July 12th. All of the statements that father's claiming these issues arising from the children occur because of their transition to Waukegan County schools was not accurate. In fact, he completely disputes that there's any issues whatsoever in his initial motion for the change in the temporary visitation. So his statements, if you read them in totality, are completely contradictory and should be considered by the court as far as what father is saying is happening with the children and what's going on. Additionally, we provided substantial evidence of just the high amount of conflict to schedule and get these children into counseling. Mother, in the assessment, it states that mother's been reporting issues since February 2022, which is when father's visitation increased, when the parenting plan that they agreed on was initiated. And there is statements that the children are expressing issues at school after spring break of 2022. This is consistent with issues immediately after the parenting plan. I know that there were arguments previously on why it wasn't brought up at that point. At that point, my client was attempting just to get the children into counseling over father's extreme arguments over scheduling and even allowing the children to attend. In fact, it became so high conflict, he's complaining that the children are crying on the phone in his statement to mother saying she doesn't want to go. And I believe this is Andy, who attended counseling much later. And mother's statement saying that when the child's with her, she's asking to go and father's refusing. This alone is a big enough issue to show that a 50-50 parenting plan and scheduling is not going to work in this situation. If father is arguing on one hand that you can't schedule appointments for the children on my time and you're giving him more time, how is that going to affect the children that are now in counseling, finally, with father actual participation and involvement? He states in his declaration that he has been involved. Let me go directly to his statements. So he mentions that in his 1114 reply declaration to our motion for temporary orders, I attended 10 plus counseling sessions for the girls and numerous other appointments and extracurricular activities just in the last 3 months. So he particularly notes only in the last 3 months this high level of participation. That's on page 4, line 10. He doesn't discuss any substantial involvement or participation prior to that time to any detailed extent like he does for those 3 months. And then again in his declaration, he states that in his other reply declaration, he states he participated in less than half of Andy's counseling sessions, 5 of 12, and mother participated in all but 1 of the 12, and stated that Ariana had been in counseling for 33 sessions, and although respondent was invited to 6 sessions for family counseling, he does not state that he attended any of these sessions. So clearly, these children, at least Ariana, has been in counseling for a substantial amount of time. Andy or Andrea has been in counseling less because of the conflict just to get her into counseling. Those are big red flags as far as how this co-parenting will work with a 50-50 schedule. The other issues that my client brings up are not only declarations from her mother and her current spouse that dictate the children being high conflict, having emotional outbursts both before and after returns from father's house. In fact, not even leaving the car for father's exchanges because they don't want to go. There is also a high level of physical, I can't say violence, but I mean, they're physical abuse like signs. There's one child comes back with 2 black eyes on one occasion and complains of being pepper sprayed. Another one comes back with cigarette butt burns on her face. I mean, those are not small actions or things that would happen normally in a household where the children are being monitored. In fact, that's our biggest concern is the lack of attention to the children's care and needs. During one occasion, child's head was held underwater, and well, to the point she could not breathe. She came back and told her mother, emotionally, that like it was traumatizing. And father doesn't address that in any details. Doesn't say it didn't happen. Doesn't say it did happen. Didn't say he was present. I mean, those types of behaviors are very concerning if the children are experiencing this level of traumatic experiences, and father saying, "Oh, everything's great. They're in counseling. I think that that's great." But yet, 6 months ago, berated my client for trying to put the children in counseling. It's a high level of conflict coming from father that just isn't apparent and providing for the best needs of the children. Specifically, their documentation of Ariana having a lot of accidents, contrary to that being what father is seeing in his home. The child's having accidents both at mom's home and at school. There's conflicts with the schools in the bus. And father says he's in communication with the schools. He provides documentation showing communications on 2 occasions. And that's not showing that he has real knowledge and involvement of what's going on with these children. All the counseling records are not provided. My client wants the children to use this as an outlet to be able to communicate and get help for their issues. But father did provide them. And despite his statements, I reviewed the 2 records he provided, and I don't see the fact showing that he's involved in participating or in any way considered a safe parent. There's, the statement from the child in the record saying, client reports, he does things to scare me and I don't like it. We tried to scare my hamster.
To the child hearsay.
And this is,
Noted.
and Your Honor, this is in the Columbia Wellness records that they provided under seal. So, I mean, at some point you have to consider what these children are experiencing in father's home. You have to consider what their reactions are and responses are going to and from father's home. And the fact that father is oblivious to these issues is more concerning than not. At this point, we are asking the court to consider the parenting plan my client is considering. If you don't want to make an extreme change, we'd at least request that there be a further investigation done. There was a guardian ad litem report done. The last time that report was completed and updated was July 14th, 2021. So it's been over 2 years. That was completed by Tina Day. I did see that following that, there was a request to implement the JO recommendations, and the court denied that in December 29th of 2021. And to clarify, when Mr. Hansen is saying that mother had a whole slew of issues, in the evaluation, it also states that mother completed a mental health evaluation with Columbia Wellness, which found no concerns. Thereafter, mother completed a full psychological evaluation with Dr. Miharg. He found no specific mental health diagnoses or risk of physical abuse by mother. So the evaluation did show other concerns, but specifically, there was nothing that showed she was going to be physically abusive or harm the children in any way. But mother did report in the guardian ad litem in her report that he has significant emotional reactivity behaviors, which include not only temper, but has threatened suicide on multiple occasions with a weapon and an attempt to hang himself with a belt. Mother states these behaviors have occurred periodically during the marriage, and she viewed them as attention seeking only. So the claim that none of these issues...
I would object as to the arguments of information that occurred, the allegation of information that's occurred prior to this, the date of this final parenting plan. We're not here to rehash the divorce. We're looking at prospectively any issues that have occurred, and it would be improper for the court to consider allegations now that are being claimed that weren't disclosed at that time.
So, Your Honor, if I may answer, Ms. McLean specifically brought up details from the guardian ad litem report and specifically stated that there were no issues or concerns about father stated by mother throughout the divorce or since the entry of the orders. I beg to differ, and I'd like to provide that information to the court.
Objections noted. Go ahead, Ms. Green.
Thank you. So at this point, obviously, my client is severely concerned about what is going on in father's household. She's provided documentation and pictures showing and I don't know if the court received the color pictures, which are much clearer. And it sounds like from Ms. McLean, if she didn't receive the emails, they didn't go through due to size. So I do apologize. I did attempt to try to provide color copies because it does show the markings on the children coming back from father. Father states that there was an incident where one of the children did a cartwheel in mom's care, and that should be considered her being an inattentive parent or some forth, trying to, I guess, minimize the number of injuries and signs of abuse that are showing up from his household. I mean, he provides one incident, and that has no way in comparison to the number of other incidents that have occurred while in father's house. So given the extreme amount of things that have changed and information that is being produced since the February 2022 parenting plan, my client is extremely concerned. The counseling records show that there's reasons for concern. The lack of father's participation and actual knowledge of what's going on with the children is concerning. We do not believe the 50-50 parenting plan is appropriate. We are asking the court to give consideration to our motion.
All right. Anything else, Ms. McLean?
Just briefly, the allegation is that the children are having behavioral issues as a result of dad, and that the court should conclude that that is the appropriate nexus. Although, if you take a look, we've had the children move to Wahkiakum County to a new residence. Their mother's gotten married. Their mother's had a cancer scare. We've got these ongoing court actions. The children are involved in counseling. There's been no mandatory report by any counselor. There's been no police report. If you go back, the suggestion that the girls are coming back injured all the time. My client denies that his daughter was pepper sprayed. Absolutely did not happen. Again, she was not there. If there was evidence of that, that should have been reported to law enforcement. That should have been reported to CPS. That should have been reported to her physician, the child's physician. Simply did not happen. The allegation that he hit one of the girls, you have a declaration from a witness who observed the child basically run into the back of his bow. Accidents happen. You have the text messages where my client told her the day it happened, when the child runs around the corner and runs into another person at a family gathering who's smoking a cigarette and is burnt. That's reported to her. Does she go to the police with that? Does she go to CPS? No. It was explained, and now she's trying to use all of these to suggest that this is showing a pattern of evidence that my client is abusive to these girls, and it's simply not true. So we're asking the court to deny the motions.
I have a couple questions, and to anybody who wants to answer them. That I understand that there were some initial struggles with counseling. They're both engaged in counseling and have been since when? Did they both? I know they didn't start at the same time. How long have they each been in counseling?
I think that one has been, I think, since I want to say July, August of last year to present, and the other I think is February of this year to present. I'd have to go back to the actual records.
So the Columbia Wellness records provided show that Ariana had her assessment done on May 2022, and I can have my client confirm when the other child started counseling. I know that there was an issue, and she is present.
I knew one of them was over a year. So I want to say the younger child, I think, has been in since, let's say, summer of 22.
Right.
And then the older child, the majority of this year. If we're talking generalities, can we all agree that that's about correct?
Sure.
Yeah, Ariana is the 7-year-old. She is the youngest that started in 2022, May.
So there's a lot of interesting allegations here. I did some of the things that I noted when I reviewed everything was that there was a filing for relocation. I noted the same thing Ms. McLean stated, that at the time of the request for relocation, there was no ask to change the parenting plan. When that was discussed, that was filed in June of 2022, I believe. And then when it was before the court, I want to think it was September of 2022. Sorry, there's a lot of documents in this case. And so Odyssey takes forever to kind of scroll through, but I think there was a continued no request to change the parenting plan. Does that hold all the water for the court's decision? No, but it's definitely notable, especially since now she's indicating that, well, right off the bat in February of 2022, things went south. And so it's something that definitely the court noticed. I will also indicate that in my review of the final parenting plan, which I have a date of February 1st, 2022 as entry of, I read this as we are transitioning to a 50-50 plan. And I agree with both Ms. McLean and Ms. Green. That's not to say that if there's a concern that couldn't be raised, but it also is an agreed parenting plan that if we get to August 2023 and we haven't got this Friday to Friday done, then it's just a motion to the court without adequate cause to say, I want to expand visitation, which is what Dad did. Dad filed the motion to expand adequate cause, the motion for summary judgment, and now we have this response from Mom and frankly a plethora of photos, text messages, information that both parties have submitted to the court. I think just in just this last week, this court received this much from Ms. Green. So there's it's almost like, and I understand that there was some motion made by her earlier this year that was denied. That was September, I guess, of this year. I just, the timing of all this is curious to the court. There are clearly, I would also agree that there are clearly a lot of changes that have happened with the kids. So not only did a new parenting plan be implemented February of 2022, 4 or 5 months later, they're moving. Then there's a new step parent involved. And a lot of different situations. I think they initially were, when they moved to Okaloosa County and that was granted, they were living with, I want to say a grandparent or grandparents. So there was a lot of moving parts for these kids over the transition from the finalization of the divorce, which is February of 22 until now. I frankly read more of the counseling information than I did of some of the exchanges. What I would say is it does appear that the parents, while they have some struggles with communication, both of them seem to be pretty upfront with providing information about this. Hey, this happened on my time. Hey, this happened on my time, which is commendable. Dad, I would argue there's nothing that shows that he hasn't been forthright about any of the issues in his home. Yes, there's other accusations. I am concerned with some of the allegations that these children are being told or given information about what's going on in the case, the adult matters. And I believe there was even I think Ms. McLean submitted something that there was, and please correct me if I'm wrong, but that another family member is going through a divorce and one of the children knew
the grandmother.
Very detailed information about exactly what was going to happen with property and different information. That's really concerning. A young child should never know any of that information about a grandparent, especially, in this kind of a situation. So I do have some concerns with how much information is being shared with these children. If there's any leveraging done with the children by either parent is also concerning. I have a lot of concerns. I will say that at this point, I can't say that the majority of my concerns lay with one parent over the other. I don't see Dad being the primary cause of concern. I do understand that there are some allegations of injuries or things happening there and abuse, but I also see some of the things that the children are relaying and saying seem to be, for lack of a better term, convenient to be telling the party that they're with at that point in time. I'm not saying that these young children are trying to manipulate anyone. I think they're trying to please who they're with. And I think that they have too much information, frankly, about what people want to hear to please them. If hopefully that makes sense. I have my initial thought after reviewing everything was to grant the expansion and deny the adequate cause. I do have some concern for these children, and I don't. My other thought is that we have Jen Schneider as the or excuse me, Jen Schaefer. Jen Schneider is someone else. Jen Schaefer is our new court investigator. And her, one of her many duties is to have a really quick turnaround on kind of like a, I don't want to call her a super GAL, but a kind of a quick turnaround investigation on situations like this where we want to ensure the best interest of the children. And frankly, I think that's what I'm going to do in this case. So I'm going to appoint Jen Schaefer to do a quick report. I'm going to essentially table all the requests, leave things as status quo, the visitation to remain as it is. And Ms. Schaefer is present on Zoom here this afternoon. And I already inquired whether she was able to take this case. I'd like to review this on the 19th of December. That's 4 weeks from now. 3 weeks from now, I apologize. And I know that's super fast. I'm not looking for, there's already a pretty substantial amount of counseling records that the parties have provided. So I don't know if there's going to be any ROI issues with that. What I really want is Ms. Schaefer to basically talk to everybody, both children, dad, mom, potentially observe some of the parenting time between children and mom and dad, and report back on the 19th. My ideal, and I appreciate everybody's patience on this because this is the first case I think that Ms. Schaefer is getting appointed. So basically it's going to be a bench order. We're working on what an order would look like to appoint her. There's no fees associated with it. So because she's a court employee, it's a little different than a GAL there. So we don't have to worry about costs associated with this. And normally her reports would be filed just like a GAL's reports would be filed. In this circumstance, given the quick turnaround, and the reason why I'm kind of pushing for the 19th, if we have to do it the 26th, we could do it the 26th if the parties are available. I don't know. I know it's a weird date for the holidays, but I'm pushing for the 19th, most especially because my domestic docket time changes. So I don't have a domestic docket starting in the first of the year. So, and because I think it's important to get a resolution for these folks and address the concerns that have been raised. So I'm going to do a bench order appointing her. And so basically all of that leads to, I don't know what kind of report she's going to be able to provide. It may be a more informal report given the quick turnaround time, but my hope is that she'd be able to provide something to the parties prior to that hearing date so you can review that with your clients before the 19th. And I will, Jen, I'll make sure to touch base with you and go over everything. Are all the parties, I just want to, since this is a quick turnaround, is everybody, everybody's information in the file, all the contact information for your clients are up to date as far as you all know?
Yes.
I believe we filed a confidential information form with our petition, so it should be up to date. But if Ms. Schaefer wants to provide her contact information, I'm happy to email her directly.
Okay. Jen, do you want to maybe put your email in the chat for?
We'll do that. Yep. Mm-hmm.
Perfect. Thank you. And then any
I'll make sure to
questions?
provide updated information to Ms. Schaefer if it isn't in there, but I believe it is.
Okay.
I believe I have all of the counseling records up until maybe, I don't know, September, October. So I can forward those to her.
Perfect. Okay. So there's her emails in the chat there. So if you want to just let her know, and then I'll work with Jen to determine, hopefully we can have it as a full report, but I don't want to put too much on her in that. And it is a quick turnaround time. So if it is an informal report, I hope you'll bear with us, but it'll at least give us a snapshot of what's going on. And frankly, the court's always number one interest is what's best for the children. So that's really, I just want to ensure, I know that they are in counseling. I know that both parties appear to be active in school and counseling, that there are some safety nets in place for these children, but there's still some things that are of concern. So hopefully both parties are available on the 19th.
Yes, Your Honor.
Yes.
Okay.
I guess just the one caveat I would tell you is that I am flying back on Monday. And I know 2 years ago I was delayed a day, but I'll make sure that I've got my laptop with me so I can appear remotely if I need to.
Okay. I'm here. Well, I wasn't going to be here the 26th, but I think I'm here the 26th now. So if we do have to bump it, or if we need to put it onto a Friday morning presentation, obviously I'm invested in this now. I want to make sure that there's resolution before I move off to a different rotation. So we'll make sure to get it handled, even if there's some hiccups along the way. I don't want to drag this out any longer.
And I'm not opposed to Ms. Schaefer just sending us all an email, and then we can print it and put it under a cover sheet to be filed under seal.
Okay.
As far as the interim.
All right. I'll work with Ms. Schaefer on that. So I'm going to do an official bench order at this point, appointing her. We'll set this to the 19th at 1:00 p.m. In the meantime, I'm going to order that the visitation schedule remain the same as in the parenting plan that's currently been followed by the parties.
Okay. All right,
I have signed the summary judgment, so I'll submit that. And I will ask the clerk to hold the remainder of the orders the parties presented for the 19th.
Okay, thank you.
All right.
There is no more new cases, but Ms. McLean and I were able to chat briefly after the Scrivener matter. And I was hoping if we could recall that real quick.
Yes.
And I can, yeah, if you want to go, no.
So after the hearing, I was able to call my client just to confirm, because if you recall, I said I hope I wasn't speaking out of turn as far as the half days versus the full days. The daycare support is only on full days, not half days. And in the meantime, and I haven't shared this with, probably because I've been in that last motion, I did ask my assistant to touch bases with Faith Family just to see what they had available. So they have a part-time, which is up to 15 days per month. The school portion is 8:45 to 11:45 a.m. And then daycare is anytime before or after. And I think their hours are 6 a.m. to 6 p.m., I believe, but I'd have to go on their website to confirm that. Their cost for that school and daycare support for 15 days a month is $705 a month. And then full-time is 16 days or more. And school is the same hours, 8:45 a.m. to 11:45 a.m. And that's $940 a month. And then they also said that they currently have a wait list for 4-year-olds.
Okay, so so
I guess maybe,
let me just make sure I'm hearing you. So if we did 3 full days, the daycare would still only be available the days that they were in the full day. So the little bit before, a little bit after. Okay, so we really are kind of back to square one, it sounds like.
Well, I think I've got a potential solution. Is if we end up with the 3 full days. I mean, one option would be that if they need daycare on those other 2 days, that they're responsible for their own daycare during that time.
What is let me see. What is the 3 full days tuition? That's 5,076 minus. Is that the 4,608?
Yes, the same. Yeah.
So the
Yeah,
three full days is the same as 5 half days. Okay. Well, that at least makes the math part easier. Knowing that, Ms. Bliss, if the essentially agreement or the new order of the court would be that if daycare is needed beyond the 3 days, each party is just responsible for their own, and dad wouldn't have to contribute to mom's daycare. And Frank, I don't know if you've been able to talk to your client, and if we need to set this over 1 week to allow for a little bit more research or negotiation, I'm willing to do that. I just, obviously that changes things in my opinion significantly. So
yeah, and I was able to discuss with my client briefly while I was waiting to recall the case. It's still his position that he would prefer not to use St. Rose. So I guess, especially given the fact that Your Honor's ruling was essentially St. Rose is a no-brainer because it includes daycare. And now that it doesn't really include daycare, aside from the 3 days, we're still going to be paying for daycare at least 2 days a week, arguably. I think we are arguably back at square one. If Your Honor's still inclined to order St. Rose, I would ask that we set it over a week.
Because I know that the parties are kind of work in opposite directions, but they live.
St. Rose is obviously in Longview, but more in the middle than they would be.
Right. Well, and arguably so would LCC. So,
and of course, there's also my client's other option would be that she pay 40% and he pay 60%, which reduces his obligation. I think she put that in her reply declaration. And if we did that, hold on, let me jump back and do the math.
Is she willing to do that for school and daycare? Just asking, because I had or conversely, I mean, and I know that there was kind of a alluding to.
So that makes her obligation 180 on the school and 180 a month, and that would put him at 270.
From 368 to 270.
Yeah.
Ms. Bliss, do you want to talk to your client about that?
I would say, yeah, I should probably chat with him about that, because that's obviously just the price for schooling, not including any additional daycare, which I think your ruling was with the intention of no longer having that daycare expense.
Yeah, that would
Well,
still
but
be
if you-
about a $98 to $100 buffer from what I ordered to pay for daycare. And I know there was a kind of, I don't, one of the parties alluded to there being some concern with dad's new partner, what her level of participation is, or so. I don't, that wasn't specifically before the court, but that obviously is a much, I mean, it's a lower number. And if daycare isn't needed, here's what I'm going to do. I'm gonna, because that is, in my opinion, a pretty drastic change in the circumstances, even though there's, and I appreciate the request to kind of change the percentages. I'm going to allow Ms. Bliss to have a little bit more time to speak with her client. And are you both available next week on the 5th?
I'll be here.
So let me check. Yes.
Okay. So let's set it over 1 week. If he agrees to that and you want to strike that and we can enter an order, great. But I'm going to pull the order that I previously signed and scrap that.
Okay.
And then if there's an agreement in the meantime, great. If not, then any additional information you want to provide the court before then, feel free to email it.
So do you want to just give us at least some parameters of what you're looking at? I mean, because
if there's another option that mom has that is agreeable to dad, if dad's okay with the 60-40, but to just do that without his knowledge or input I know that Ms. Bliss indicated that there was she was able to quickly address it with him. The daycare only is for full days. But I don't know that doesn't sound like you were able to really discuss much beyond that.
And what I meant by my inquiry was, what was, when you were approaching this, what were you thinking as far as threshold amounts? Because that will give Carly and I some more work room to try and come up with something a little more creative.
Threshold amounts?
Yeah, is there a threshold amount that you were expecting to limit?
For cost of schooling?
Well, I'm assuming for his obligation.
Oh,
because that seems to be what we're driving this force on now, apparently.
I'm concerned that, to be very frank, I'm concerned that she wasn't willing to think of anything besides St. Rose. He provided 2 or 3 different options to which she was unwilling and only wanted the one that cost money. So I think I would be looking at him not having to pay more than he's probably been paying in daycare for schooling, if at most. And I was willing to go up. It was approximately $50 than what I averaged out his daycare has been in the last year or calendar year. So hopefully that helps answer that question.
Okay.
That should be fine.
And I guess, well, no, never mind.
Am I still not answering your question?
No, you're answering my question, but I mean, the continued suggestion that she's not taking on these free options, how do we do transportation and daycare for that to be accomplished? The only way you do that is by having a daycare who will actually transport. And then you're back at Faith Family, which I think is the only place. I don't know about this Lexington gal. She was across the street from the school. So yeah, it'd be easy enough for her to potentially walk this kid across the street. When you're talking about somebody.
Is that the KT?
Yeah.
TK. Mm-hmm.
TK, sorry.
When you're actually talking about getting the child to and from LCC Head Start, who's going to do that? The only person that's going to do that right now that I know of, unless Carly knows somebody else, is Faith Family. We're going to be paying for transportation and for daycare, which is going to exceed what they're both currently paying. So the suggestion that she just denied the free option ignores the fact that we still have transportation and daycare issues that we still have to work out for these parties to pay for.
But that's going to be an ongoing issue for the rest of this
Correct.
child's life until they're of age to be home alone after school or in after school activities. So this is,
I understand.
we're going to have to figure it out somehow. And I'm not suggesting that St. Rose isn't the best option, but she didn't try to look for anything. As far as anything that you've submitted to the court, Dad's the only one that looked at different options. I understand that those may not be ideal given the circumstances that they both live different places, what's available. LCC, if all they have is 3 days of half day, yeah, that probably won't work for them. And it makes sense that maybe we need to look something else. But if there's 5 day options somewhere, if there's, I guess at this point, I'm not really concerned with 3 day versus 5 day, just because mom thinks it may be too much. If there's a 5 day option and it's free that works within the family's scheduling, then great. So ideally, I'd like to not have to make this decision because I don't know all the ins and outs of everybody's life and what's going on. Obviously, that's what we're here for if we can't agree. Given the information I received initially, St. Rose did seem to be the option that was best, especially because it included that daycare. Now that we know that it doesn't, and there's going to be an additional cost on top of that, I just want to ensure that there's not other options or an agreement that can be reached between the parties. And as I stated, I do appreciate that mom's willingness to increase her proportional share of St. Rose. I just don't know. I want Ms. Bliss to have an opportunity to discuss that with her client. Frankly, to me, 180 and 270 is proportional shares. And then him still having $100 to deal with any daycare costs that may arise every month seems reasonable. So at this point, that's likely what I would order unless there's some other options that are agreed upon or other information is provided. So if she's willing to do 60-40 at this point, that's what I'd be leaning towards and stick with St. Rose.
Okay.
But and I'm not trying to say that Ms. Scrivener is being, irresponsible in trying to address this or that she's shirking any responsibility, but she hasn't provided any other options besides this one. So if there is another option, if there is a 5 day option, I don't know at Head Start if TK has a 5 day option and there's a new opening now and there isn't a concern with using grandma's address and it's right across from where daycare currently is. So at this point, I guess to preview my thought process is 60-40, sticking with St. Rose is likely what the court will order, barring any, pertinent information or a drastic change in circumstances or an agreement of the parties.
Okay, we'll see if we can get it worked out, but we'll be back.
Okay, perfect. Thank you very much.
Thank you.
All right, have a good afternoon.